Well, this is the video segment covering employment relationships and employment law in the legal environment of business class. We got a lot of ground to cover, so we're going to cut a few corners a little ways down the line, and you'll see what I mean when I talk about that. Well, first, let's talk about different types of relationships that employers may have or companies may have with potential employees, agents, or independent contractors. We'll start with the actual agency relationship itself. You have a principal or a person has or a company has a relationship with an agent. That agent can act on behalf of the principal, can sign contracts and enter into various types of agreements and transactions on behalf of the principal. And if the agent has the authority to do that, the principal is then bound by the acts of the agents. That can also apply with torts. Before I go on there, I just want to point out that an agent can sometimes be an employee, like officers of a corporation, or an agent is sometimes not an employee, like you might use an agent to purchase or sell a house for you. So you need to identify whether or not the agent is an employee. If the agent is an employee and acts on behalf of the principal or the employer, there may be times in which the agent engages in negligent or inappropriate behavior. For example, the agent or the employee is driving a company truck with the company's logo on the side and negligently gets involved in a motor vehicle accident. In that type of situation, the liability could go to the principal or the employer or the person who hires the agent under the doctrine of respondeat superior, which is Latin for the principal writes the check. I'm kidding, of course, but that's pretty much the legal consequence of it. The principal becomes liable as a result of the negligent acts of the agent or employee while they were performing duties within the scope of their employment. So in that fact pattern, the employee or agent while driving was on the job. Let's take a look at situations involving contracts where you have the principal and the agent and the third party. In a situation like this, again, when the agent has authority to do so and they negotiate with on behalf of the principal, then the principal is then bound by the acts of the agents, signing of contracts and so forth. That is contrasted with the relationship between a principal and an independent contractor and third parties. In situations where the independent contractor enters into agreements with third parties, the principal is not usually bound. Say that you hire an independent contractor to build a patio on the back of your house, and he wants to pour a concrete deck, a concrete back slab on the back of the house. He contracts with a cement company, writes them a check, but the check bounces. The cement company can't come after the principal because the independent contractor is not acting on behalf of the principal. He is an independent contractor and is responsible for his own bounced check. The doctrine of respondeat superior does not apply. This particular slide gives a nice summary of the different types of relationships between principals and these other parties: employer-employee, principal-agent, and principal versus independent contractor. Principal and independent contractor, rather. What we just kind of covered in all those little diagrams. Moving on. In order to form an agency relationship with someone to serve on your behalf as an agent, can be expressly done through an oral or written agreement, an agreement between the parties. It can be an implied agency based upon the conduct of the principal and the agent. It can be implied that an agent does exist. They do not expressly create the agency, but it is possible to infer that an agency exists as a result of the conduct of the parties. Express agency or implied agency. Forming the agency relationship, sometimes it looks like there's an agency that exists, or one of the parties may create the appearance or represent that there is an agency relationship, but there actually is not. excuse me, in that situation, the principal would not be bound. But if the principal does ratify the actions of the let's say, unauthorized agent, then the principal would then be bound, when under normal circumstances, the principal would not be. That can be done by ratification. Let's take a look at employer liability. We already talked about respondeat superior. If the person is taking an action, again, driving the company truck while on the job and is involved as a result of their negligence in a motor vehicle accident, the liability will flow to the principal, the employer, under the doctrine of respondeat superior. Typically, criminal conduct or other type of conduct outside the scope of the employment releases the employer principal from liability. I have a friend who had a company, and one of the employees without authorization took a company car and went up north to visit a girlfriend, and along the way was speeding and got involved in a motor vehicle accident. That was totally outside the scope of employment. That person was injured, but it was all due to their irresponsibility and their arguably unauthorized and criminal conduct as a result of taking a car that did not belong to them. So you got to take a close look at the facts to see whether or not the employer is liable based upon the conduct of the agent or employee. Now, also in this segment, there were a lot of slides pertaining to federal employment laws. We're going to discuss those in depth at the time of the class session, starting with the Fair Labor Standards Act that was passed in 1938 during the initial part of Franklin Roosevelt's term as part of the New Deal and to try to get the country out of the Great Depression. If you look at some of the provisions of this Fair Labor Standards Act, you're kind of going, my goodness, this is all pretty much common sense. You know, a 40-hour work week, overtime pay, record-keeping requirements, a minimum wage, I believe also child labor laws, all these standards that we pretty much take for granted today, but they were not the norm back in that time. And it was a way of regulating the workforce and giving workers rights, so they, if they had to work overtime, they got paid for it. Prior to that time, it was common for employees to work 7 days a week and not get paid overtime, work long hours for low wages, and this pretty much changed everything in that area. Well, we've got all types of acts like that in the slideshow presentation, which you can see in the whole separate PowerPoint presentation that is in Canvas, covering all types of acts from that first act from 1938 all the way to the Patient Protection Affordable Care Act, also known as Obamacare, passed within the last 10 years or so ago, increasing availability for medical care to the general population. Rather than go over every one of those and have you experience death by PowerPoint, again, we'll discuss that more in class, and you can take a look at those particular slides on the PowerPoint presentation that is included in Canvas. So let's see what else we have to take a look at here. There's workers' privacy that's been enacted as well. Again, we'll talk about all these things in the actual class session because, again, if I try to summarize it, it's just going to be basically what's on the slide, and you can read that without my help. So that pretty well covers, as best I can with this limited video format in this segment, the employer rights and employer-employment relationships in this segment, employment relationships and employment law. I hope that you're doing well. Hope that you're staying safe. And once again, hopefully you're enjoying your class, and we'll see you soon. Take care.